Welcome back to the Deep Dive. Staying on top of all the changes in the professional world, it's always a challenge, isn't it? Especially when it comes to something as fundamental as employment verification. Today, we're really zeroing in on a pretty pivotal update, something that's, well, significantly impacting how employers and employees handle work authorization in the U.S. Think of this as your kind of shortcut to understanding a really important new development in the E-Verify system. So our mission today is basically to unravel this new feature. What does it actually mean for businesses day to day? And crucially, what do employees need to know to, make sure everything stays compliant and smooth? This isn't just some minor tweak.
No, definitely not. And understanding legal work authorization is just so fundamental for any U.S. business, really, big or small.
Yeah.
This specific E-Verify enhancement, it's really designed to streamline compliance and maybe more importantly, cut down on risks for companies. It's all about ensuring you have a legally authorized workforce while, trying to navigate these pretty complex federal rules.
Right. So to really get our heads around the impact here, maybe we should start with the basics, just to make sure everyone's on the same page. For anyone maybe less familiar, what exactly is E-Verify? At its core, it's the U.S. government system, right? An online one.
That's right. It's an internet-based system. Basically, it lets employers confirm electronically if their employees are eligible to work in the United States. It works by comparing the information from the employee's Form I-9, the Employment Eligibility Verification Form A. It compares that info against records held by the Department of Homeland Security, DHS, and also the Social Security Administration.
Okay, so it's a verification tool.
A powerful one, yeah. And it's constantly being updated, like with the change we're discussing today, to help maintain that workforce compliance.
And central to this whole discussion is the Employment Authorization Document, the EAD. Can you run us what that is?
Sure. The EAD is essentially a work permit. It's temporary and it's issued by USCIS, that's U.S. Citizenship and Immigration Services, which is under DHS. It provides temporary employment authorization specifically to non-U.S. citizens who need it to work legally. It's not for everyone, though.
That's a really important point. So who actually needs one and who maybe doesn't?
Exactly. It's crucial because it's not universal. For example, lawful permanent residents, green card holders, they don't need a separate EAD. Their status itself allows them to work. Same goes for people on certain non-immigrant visas, like, say, H-1Bs, L-1Bs, O visas, P visas.
Yeah.
Their specific visa status already includes work authorization.
Okay, so their visa is their permission, in a way.
Pretty much, yes. But for, well, most other non-immigrant visa holders, think about international students on optional practical training, OPT, that's a common one, or individuals who've received asylum or parole status. For them, unless they have some other specific work visa, an EAD is absolutely mandatory to work legally in the U.S.
Got it. So that distinction is key. Now, here's where it gets really interesting and kind of the core of why we're doing this deep dive, this big update. What exactly changed? I understand there's a new field in a report.
That's the heart of it, yes. The major update is the addition of a revoked document number field, and it's specifically within the E-Verify status change report. This field officially went live on July 15th, 2025.
Okay, July 15th. And what about the report itself? Was that new too?
Good question. The report itself, the status change report, actually launched a bit earlier, back on June 20th, 2025. Its initial purpose was already to help employers spot employees whose EADs had been revoked by DHS.
Oh, okay. So the report existed, but this new field makes it more specific.
Exactly. That's the crucial enhancement. Before July 15th, an employer might see that an EAD was revoked, maybe listed by name or a number, but matching it directly to the specific card the employee presented for their I-9 wasn't always straightforward. An EAD could be revoked for various reasons. Change in status, a legal decision, sometimes even an error. But if the physical card still looked okay, still had a future expiry date.
An employer might not realize it's no longer valid in the system.
Precisely. They could unknowingly keep employing someone whose authorization was pulled. This new field closes that gap. It's like a direct digital red flag tied to the document number itself. It allows employers to take the EAD number they have on file, the one from the Form I-9 and the E-Verify case, and check it directly against this DHS list of revoked numbers.
In near real time, you mentioned.
Yes, that's the goal. It makes the process much more precise and immediate, protecting businesses from, non-compliance issues they might not have otherwise caught so quickly. It's a significant step up in terms of system integrity.
Wow, okay. That definitely sounds like a game changer. So what does this mean practically? For the employer on the ground, what are the steps they absolutely have to take now?
Right. These are mandatory actions, not just suggestions. First, employers must run that status change report regularly within the E-Verify system. They need to be consistently checking if any of their current employees' EAD numbers show up on that revoked list.
And regularly is the operative word there, I imagine, not just once a year.
Absolutely. It can't be a one-off check. This needs to become part of the routine compliance process. How often? Well, that might depend on the workforce size, turnover rate, maybe weekly, perhaps even more frequently for some. The key is catching these revocations quickly after DHS flags them. You know, better safe than sorry with potential penalties.
Makes sense. Okay, so step 1. Check the report regularly. What's next if they find a match?
If a match is found you see a current employee's EAD number listed as revoked. The employer has to act immediately. They must re-verify that employee's work authorization, no delays.
Immediately.
Okay.
And how do they do that? Is it a whole new I-9?
No, and that's important. The re-verification must be done using Form I-9 Supplement B. Supplement B is specifically for re-verification and updating work authorization. It attaches to the original Form I-9, so you're not starting the whole process over, which is, more efficient.
Right, using Supplement B. And this is required even if the EAD card itself looks perfectly fine, like the expiration date hasn't passed.
Yes, absolutely critical point. This step is mandatory, even if the EAD appears unexpired or looks valid. The physical card might not reflect its revoked status in the DHS database. The report trumps the card, essentially.
Okay. And when they do this re-verification using Supplement B, what documents can the employee show?
Good question. The employee needs to provide proof of their current employment authorization. Employers can accept a document from List A, which proves both identity and work authorization, or they can accept a document from List C, which proves only work authorization. If they provide a List C document, they'd still need to satisfy the identity part, usually covered by the original I-9, but the focus here is the authorization.
So List A or List C. What about List B?
List B documents, which only prove identity, like a driver's license, are not acceptable for this re-verification purpose. The goal is to reestablish work authorization.
Got it. And just to be crystal clear, the revoked EAD itself, even if it looks okay, cannot be used for this re-verification.
Absolutely not. Once that EAD number appears on the revoked list in the status change report, it's invalid as a proof of work authorization, regardless of what the card looks like. It's off the table.
Okay. And they update the existing E-Verify case, not start a new one.
Correct. Don't create a new E-Verify case. Use the existing one and just update it with the information from the new document presented recorded on Supplement B. Following these steps correctly is crucial for compliance. Ignoring them or getting the procedure wrong could lead to, significant legal trouble and penalties. This update really places the responsibility on the employer for proactive monitoring.
It certainly sounds like it. Now, while employers need to be diligent about this, there's always the concern about potential discrimination, right?
Yeah.
How does that fit in? I mean, you're suddenly asking an employee for new documents. How do employers handle that carefully?
That's a vital point, and DHS emphasizes it. While these new requirements demand swift action, employers must still follow all the standard Form I-9 rules and critically avoid any discriminatory practices during re-verification. This is purely about compliance with authorization status, not about singling anyone out based on their background.
So it's about applying the process consistently if a revoked EAD is flagged.
Exactly. Consistency is key. And DHS specifically prohibits certain actions to prevent discrimination. For instance, employers cannot demand more or different documents than what's legally required for Form I-9 completion or re-verification.
So no asking for extra proof just because.
Correct. They also cannot demand that the employee present the same type of document that was initially presented. The employee has the choice of which acceptable documents to show from List A or List C.
Okay, employee choice is protected.
Yes. And importantly, employers cannot reject documents that reasonably appear to be genuine and relate to the person presenting them. The bottom line is non-discrimination based on national origin, citizenship, or immigration status. The re-verification process must be fair, impartial, and applied uniformly to anyone whose EAD appears on that revoked list.
That balance seems really important. Strong compliance measures, but with clear anti-discrimination safeguards built in. You mentioned the speed of these changes earlier. Maybe it would help to quickly run through that timeline again. It sounds like things move fast.
They really did. It highlights how dynamic this area is. So thinking back, EADs revoked between April 9th and June 13th, 2025, Those were initially added to the system around June 20th.
Okay, April to mid-June data was the starting point.
Then, June 20th, 2025 was the official launch date for the status change report itself.
Got it. Report launched June 20th.
After that, more revocations covering the period from April 9th through July 8th, 2025 were included in the next big update, which was July 15th.
And July 15th, 2025, that was the key date, right? When the revoked document number field actually appeared.
Precisely. That's when the functionality we're discussing really took effect, allowing that direct number matching.
Okay. Any updates since then?
Yes, the system continues to be updated. For instance, by July 29th, further updates reflected revocations that occurred between April 9th and July 24th, 2025. That date, July 29th, is also when USCIS last provided updated guidance on this topic.
Wow, that is a rapid rollout and update schedule. April, June, July.
Yeah.
Multiple updates incorporating more data.
It really underscores the push from DHS for, well, near real-time compliance. This isn't a slow phase-in, it's evolving quickly, and employers just have to keep up to stay compliant with federal immigration laws.
It definitely sends a message that relying on old information or delaying checks isn't really an option anymore. The I didn't know defense seems much harder to make now.
That's a fair assessment. It signals a strong commitment to making sure the system reflects current realities, effectively closing that latency gap for revoked EADs.
So let's tie this all together. Why should this update really be on everyone's radar, whether you're an employer, an HR pro, maybe even someone holding an EAD? What's the core risk or the main takeaway here? Is it fundamentally changing how employers need to think about I-9s?
I think it is, in a way. This change gives employers, as we said, a crucial tool. It lets them identify revoked EADs much faster, almost in near real time. The big shift is that even an EAD card that looks perfectly fine, unexpired date and all, might no longer be valid proof of work eligibility if its number is on that revoked list.
So the physical card isn't the final word anymore.
Not if it's been revoked in the system, no. Before, there was that lag, that potential gap in knowledge for the employer. Now, the expectation is that employers use this tool. So, without properly checking this report and acting immediately on any matches, employers really do risk significant non-compliance issues with federal immigration laws. Think fines, audits, potentially worse.
It really raises the stakes for proactive verification.
It enhances the integrity of the whole system, yes. Making sure people employed are actually authorized to work at that specific time.
Okay. So as we kind of wrap up the details, let's do a quick recap. What are the absolute essential points people need to take away from this deep dive? Number one seems to be run that status change report regularly.
Absolutely. Regular, consistent monitoring.
2, if you're an employer, actively compare the EAD numbers from your employee I-9s against the numbers listed as revoked in that report.
Yes, make the match.
3, if you find a match, you have to re-verify immediately using Form I-9 Supplement B. No waiting.
Correct. Immediate action with the right form, even if the card looks fine.
4, when re-verifying, the employee gets to choose what acceptable document to present from List A or List C. No dictating specific documents.
Employee choice is paramount, yes. List A or C only.
And finally, number 5, throughout this whole process, avoid any discriminatory practices. Follow the I-9 rules carefully and consistently.
Crucial. Fairness and consistency are key.
That seems like a solid checklist.
I think so. Looking at the bigger picture, the message is clear. Employers need to be proactive. They have to monitor for these revoked EADs and address them correctly when found. It means staying current with E-Verify guidance, keeping accurate I-9 records, and handling any revocations through that specific re-verification process. Doing so protects the business, ensures compliance, and also respects the employee's legal status.
It really speaks to a more dynamic regulatory environment, doesn't it? Where vigilance and proactive steps aren't just about ticking compliance boxes anymore. It feels like it's more about building and maintaining a workforce that's secure and fully legally sound. So maybe the final thought for listeners is, in this evolving landscape, the question isn't just, am I compliant today? It's maybe, is my process agile enough to stay compliant tomorrow? And maybe for employees too, am I aware that my authorization status can change? And do I know what to do if it does? It demands a new level of awareness from everyone involved. Makes you wonder what other tools or changes might be next, right?
Indeed. It highlights the continuous nature of learning in this field. Immigration and employment law, they're always evolving. Staying informed and adapting is just part of the process now.
Well said. All the best, and we will meet again with another important matter again.